We move to the third and final paper from Julien, which I suspect will put a challenging spin onto the entire discussion that we are having here. It is entitled provocatively, Rights of Nature, Why It Might Not Save the Entire World. Thank you.
Thanks a lot. Good afternoon, everybody. I'm very happy to be here, and I would like to thank the organizers of the conference. I'm coming from the University of Toulouse, which is just 4 hours from here on the other side of the Spanish-French border. My starting point on rights of nature a few months ago was this book of David Boyd, who is famous because he wrote a previous book already called Legal Revolution on Global Constitutionalism, etc. And he found a new revolution in rights of nature. So I was a bit surprised, amazed by the title of this book, wondering where is the revolution here. Why? Because when I was doing my PhD, I often, of course, read Christopher Stone's article, 1972. So it's not a new approach; it's an old approach. And this article was very stimulating for me. But I reached the conclusion that giving legal personality to nature was not absolutely necessary because we already have tools in the EU, as you mentioned. So I'm not going to repeat things that has already been said. Just going directly to a definition of rights of nature, which I call RUN. It's the acronym. It refers to giving legal personality to nature and also giving substantial and procedural rights. One important point here, in order for everybody to understand what I want to say, is my methodology. I think, like Gaston Bachelard, that scientific observation is always a polemical observation. So my goal here is not to start a battle with RUN supporters, but just to create a debate, because I think that it's with critics that we can have more knowledge on this point. And I must confess that if I try to distinguish my thinking, I can say that as a citizen, I fully follow the logic of rights of nature, and I'm very seduced by this philosophy. But as a scientist, or at least as an academic lawyer, I must, because I'm in the academy, I must be critical, skeptical, in order to assess it. What is my main argument here is that yes, we have very different philosophies here between RUNs and CEL, classical environmental law, the environmental law from papas and mamas. But I think if you look at, if you take the glasses of the legal theory, you will not find so much big difference between the two approaches. So my goal is to criticize and discuss this opposition. So that's why I was surprised by Boyd's title, because to me it's not a legal revolution. And I will go to the conclusion that RUN might face the same challenges than classical environmental law, which has been mentioned in your conclusion, which is enforcement, implementation, compliance, effectiveness. So if we leave philosophy, ethics, religious or political dimension of RUNs, I think it remains almost so very few input from this approach. So here are my 3 ideas that I will develop. The first one is that a classical environmental law is able to integrate the intrinsic value of nature. I give you a few examples. You will read in a lot of books that environmental law is very bad because it's anthropocentric. Okay, but maybe it was the case 20 or 30 years ago. But I think now we can't say that it is only anthropocentric. One example of this is the French Constitutional Charter of the Environment. I'm sorry to give you French examples, but that's what I know better. And you see here in the text that the idea of the interdependence between man and mankind and nature is very in the heart of this constitutional charter. Also, the right to property is not always dominating everything. It's every day in constitutional courts. It is conciliated with other public interest and especially with environmental interests. We have interesting decisions from the European Court of Human Rights on that ground, and also the specialists of civil law. They develop a series on the abuse of right, which is applicable to the right to property. So I think we can do something. And also 2 more examples on the natural resources issue, because I know in South America it's a very important issue linked to rights of nature. France prohibited fracking in 2011, and recently we don't have any petrol in France, but we took the decision to prohibit the exploitation of oil 1 year ago. So what I want to say is that it's not a matter of giving rights to nature, it's a matter of political will. And here we have to remember how Marx analyzed law. It remains the result of power relations. And legally speaking, runs do not change anything on this ground. Also, the intrinsic value of nature is, I think, in the heart of environmental law. We have a few examples. That's not true for this concept of ecological services, which I think is not very good. But that's true for classic nature conservation law, because if you take the example, of the brown bear, I know a little bit of this because I live close to the Pyrenean Massif mountains. So we have bears there, and when you ask to scientists why do we protect bears, they answer that it is not useful for us. It's just a matter of principle. So we are not always, we don't have always a utilitarian vision. Nature conservation, it's also a matter of principle. And you have also interesting concepts in the Habitats Directive or in the case law of the court, like the concept of ecosystems integrity, which I think refers to the intrinsic value of nature. It has been mentioned that we have a directive on the environmental liability, and especially in France, we have courts accept to compensate the pure ecological damage, which is the ecological damage which have no link with a human being. Okay, it's really the damage to nature as itself. So I think here we have an answer for a stone view on this point, and this has been integrated in the civil code quite recently, and it works before the courts. Access to justice, it's the starting point of Christopher Stone's article. It's the story of the mineral king, etc. And if you look at what is happening in Europe, we have the Aarhus Convention. And the Aarhus Convention, I'm sorry to say that, but it's the contrary of Christopher Stone's vision. It says, okay, we're going to use people, we're going to use the public, we're going to use environmental NGOs because they are altruists and they want to protect the nature. So we're gonna give them a broad access to justice, and they will defend the environment before the courts. So I think that's an alternative system to the Stone's system, which is, of course, it's not perfect in the EU, and you mentioned the limits, but I think it's a matter of evolution. We can improve this system on the practical ground, but I think it can work. And I must mention that the Latin America and the Caribbean just adopted this year a convention on the same topic, which is also very, very interesting. I won't develop on the French example, but another argument from Stone is the burden of proof. Again, I think we can lighten the burden of proof without giving rights to nature, without recognizing the legal personality, and we already do it. I give you here an example of the case before the European Court of Justice, which says that the member states can implement presumptions in pollution matters, which is of course very, very interesting. So I think that nature can be protected without giving legal personality to nature. And I think that the development of environmental law demonstrated. And I reached the conclusion, the provisional conclusion, that RON are not the only way to save the world, unlike Boyd's in his book. And this is good news because we have a lot of ways to save the world. So now I turn to a bad news for RON's supporters. It's the second idea, because I think it's the main RON's aporia, which has already been mentioned in the debates previously. I think it's going to be very hard to protect nature legally, and I insist, legally speaking, without humans. Why? Because law is a tool of humans. It's a tool of humans, not only for humans. It's for humans, but it can also be to protect nature. But it remains a tool of humans. So, if you want to protect nature by using law, you will always be in an anthropocentric approach, because it's law. Then you can see that with around the debate with the guardians. Who are the guardians? Look at the Ecuadorian constitution. All persons, communities, people, and nations. It's still humans. The guardians are the humans. And if you look at the legal personality given to rivers, it's still humans. And it's not very far from the way we manage it in Europe, as you mentioned as well. And on a legal theory ground, I also think that if you look at rights of nature, it's basically about the same than classical environmental law, because it's always an obligation of humans regarding the protection of nature. If you look at the human right to the environment, it is basically a duty for the humans to protect the environment. And if you look at the nature's right to be protected by humans, it is basically a duty for humans to protect the environment. So now you see that we are debating since Stone's article, and we are coming back to the same point. So I arrive at my third idea, which is which is an issue that is not directly addressed by the rights of nature theory, which is, I think, the most important issue, which is the effectiveness issue. So, when you look at the theorists defending rights of nature, they always, often they start by criticizing the lack of effectiveness of existing classical environmental law. So I think that's a bad start because it's partially false. I must explain a little bit to say that classical environmental law, of course, is not enough to reach the goals, but it's relatively effective. I don't have time to develop, but we can discuss it. We always see the glass half empty, and I just ask to see it half full. And then I think the real challenges are the implementation and the enforcement, and there's a lot of work to do. But of course, it's less seductive, it's less sexy than speaking about philosophy and rights of nature, I must admit. But I think the proper work is on the effectiveness ground. I have a list here of work to be done, and the conclusion is that I think we are in the academic community we are all trying to find new solutions, better solutions, and I think we are all going in the same way. But as lawyers, I think what is the most important, but it's only my view, it's what Hart said, what Hart described as secondary norms and not primary norms. So that's why the same question is still on the table. I think that rights of nature are still the wrong answer to the right question. And I want to finish by telling you that I personally don't want to replace environmental law by rights of nature. I don't want to put classical environmental law in the bin because I think we are facing an ecological crisis, and it has been recalled previously, and I think it's not the right time to change our horses, because even if the rights of nature horse is supposed to be younger and supposed to be faster, I think that we have an old horse which is called environmental law, and that can be still useful. Thanks.
Thank you. So I suspect this will give us some food for thought and some points to discuss. Just perhaps a quick question to the organizers. Would it be okay if we go 5 or 6 minutes? Is it fine? I don't know how tight your schedule is afterwards, because we're running a little bit late. About 5 or 6 minutes? Excellent. The floor is open for discussion. Any questions? Yes, there at the back.
First of all, congratulations for the speech of everyone. And I would like to say to Julien 2 questions. One of them is that when I was listening from you that now is not the time to recognize rights to the nature, I think about the same discourse about the woman until a few years ago. The law say all the time, from the modern law, from the 2 centuries ago, that the woman is not a person to have rights. That's impossible. It's like now you say about the natural. And the natural and the woman, both are being excluded of the law. And now is our time. And the second question to say you is that I understand you because you are talking from a lawyer like me. I was a lawyer for a long time, until now, I just study from the philosophy of law. Then there is a difference from dogmatic, like you, that you can create a new model, but from philosophy of law is our obligation from the academy to create new way for a new civilization or moment into the same civilization. And the base of the democracy is the evolution. And we can say it's impossible to evolve. So from the dogmatic, I understand you. From the lawyer, could be. But from the philosophy of law, no. It's our time. The nature and the woman, I think.
Thank you. Please.
On the last question, I totally agree. But as I mentioned in the beginning, it's just one point of view to debate, and if the philosophy of law wants to create new models, we are here to discuss it. Like with the anthropology presentation, it's interesting to discuss, because if I stay with lawyers, we are not a lot to say, and if you stay with philosophers, you have not a lot to say. So if everybody is agree, okay, we just go to sleep, and so that's why we are here. It's to discuss, and that's good. And the first question, it's hard because when you read at Stones, it gives a lot of example, and of course when you read, you say, okay, yes, slaves, women, and children, and companies, etc., etc. It's very convincing, but what I'm saying here is it's not that we don't have to, that I'm not against protecting nature, like I'm not against protecting giving rights to women. It's just my point is how to do it. What is the most effective way? And my point of view is that giving rights as a legal technique, it's not. I'm not telling it's not effective. I'm just telling it's not a miracle solution. That's it, and that's why I reacted in front of the title of this book.
Thank you very much. Hendrik, you wanted to say something on this?
Yeah, it's on. But from an effectiveness point of view, I think you see also from a lawyer's perspective, I mean, it's not easy to claim standing. I know the Artists' Convention has improved matters, but you, as an individual, let's assume that let's take the example of you live somewhere in the heart of Spain. There are not so many houses surrounding you. There is no environmental NGOs, and at some point, an harmful activity is taking place. It's being authorized by the government. It's at 2-3 kilometers distance from where I live, so I have no direct impacts. But I go walk there. Perhaps that's an individual interest, but it's not settled case law in any event. So the standing in such cases is very hard. I mean, in Flemish region, we're lucky to have urban sprawl. That means everybody is living everywhere. So you often have an individual interest. As a lawyer, it's very helpful. It's ironic to say. But I mean, in other countries, that if you don't have an NGO, then as an individual human being, you might, if there are rights of nature in the Constitution, you might claim standing. And even from an effectiveness point of view, I think in this specific context, rights of nature, if you enshrine it in your Constitution as basically the foundation of your environmental law, because they're not mutually exclusive. You can still keep environmental law to a certain degree as it is, like the framework, Water Framework Directive, and so on and so forth. Habitat Directive can remain in full force in the European Union, but the underpinning might be different, and I think it can make a difference on the ground, even from a pragmatic point of view. I think.
Yes, but so I think this is a matter of the implementation of the Article 9 of the Artists' Convention. I think we have everything needed to deal with this issue, but. I read an article comparing Costa Rica and Ecuador. In Costa Rica, there's no rights of nature, and Ecuador has rights of nature. And the article concludes that there are a lot of debates in Ecuador. Maybe somebody knows more than me about this point, but apparently there is a lot of debates about standing in Ecuador. And in Costa Rica, standing is broader. So you see, what I mean is that when you have rights of nature, it's not a miracle.
No, it's not a
on
miracle
the understanding point of view. So.
But I think if you were to implement it, it can serve as a kind of miracle in these specific contexts, because Article 9 does not claim that there is a free standing for every individual in every environmental case. You need to have some interest at least, and there is no case law as of today that is granting individuals the right to go to court as a kind of actio popularis. Of course, what you could do is write down in your constitution that there is actio popularis, but then you partly also implement what Stone is saying to a certain degree, I think.
Thank you.
I have a question
there, and then two in front, and a final one there today.
Yeah, my question is for Hendrik. Congratulations for the speech. Do you think that the situation of standing in the European Union and in the European Court of Justice will change after the Compliance Committee case number 32?
I'm very skeptical about it, since the debate has been going on for decades already, and there was already a provisional finding of the Aris Compliance Committee, I think in 2011 already. It didn't affect the position of the EU judges. I've even been told that the Aris Compliance Committee at some point met up with the EU judges, so they're in close contact to some extent. And no, they are convinced that by watering down their standing rules, that they would open the floodgates. And I can't really understand this reasoning. At some point it will have to change. Of course, this is to be distinguished from rights of nature as such, but it could be, I mean, Stone might be right if he were to take into account the case law of the Court of Justice on standing. He might have a point that nature cannot, but at some point you could also say, I mean, the European Court of Justice is doing great things, don't get me wrong. For instance, today I read that they have upheld a ban on pesticides that are harmful for bees. So they're doing great stuff, but at this point I think they might be wrong, and at some point they will need to take into account this Aris compliance decision, I think. But when? Yeah.
Thanks.
Thank you very much for your presentations. I absolutely agree on many of your points, Julian. I come from Ecuador right now. Like, all of those points have been raised already, and especially me personally, I'm very skeptical about the further development in a country that depends highly on extractives.
Yeah.
Having said that, I wanted to ask you a question for three of you. It's a thought-provoking question. What happens when you have conflicting natures? Maybe that's a point that you didn't raise, but I think that in Ecuador we're having that problem. You have actually conflicting natures. You have man-made nature from the one side, which is completely legitimate under our own constitution, but on the other side you have like natural nature, so to speak, which is completely, subjective at some point. So I wanted to, see your comments on that. Like, how do you resolve that?
Should we perhaps, Katarina, do you want to say something about this?
Sure. Yeah.
Thank you.
I mean, my feeling on that question is that we really should, as much as possible, leave nature to be in its processes, nature processes. Really, if we try to go in and correct the nature, that's certainly not the intention with the rights of nature framework. It's much more about the human relationship with nature. And as far as nature is concerned, I think that we have to take a step back. Perhaps there are some exceptions if there are some really destructive things going on that would have really large-scale impacts, and we might think about that. But my gut feeling is really that we need to let nature be as much as possible.
Could I perhaps just, in the interest of time, say that we move on, because we're fairly over time now. So the following question and then the last one at the back. Thank you.
Thank you for the presentation. I have a question for Hendrik regarding the trans-territorial jurisdiction, because as was said, the European countries have a big ecological concern regarding to Europe. But what would happen if, hypothetically, if a European country invests in some activity in Latin America, for example, and it generates a very big environmental damage, could it be possible in some way in the regional level or in the national level to demand some kind of reparation or even to stop this activity in Europe? And I have some observation for, I forgot your name?
Julien.
Julien, yes, because it's actually, well, in this discussion about the importance of natures, of rights of natures, maybe for some communities, for some countries, it is important in a way of recognition of particular worldview. Maybe for Europe that is not a part, but maybe for as indigenous communities have this worldview, and the recognition of this cosmovision in the constitution is a symbolic gesture of recognizing the roots. So maybe for countries that have massive indigenous peoples, it may be it would be an argument pro ecological rights.
Thank you for your question. I think it's a very seminal issue to be addressed. I think a couple of days ago I read a paper on the restoration of forest, where the scientists concluded that rich countries are doing a lot of efforts to restore their own forest, but they're exporting their damage to other countries. So that, of course, it wouldn't make sense. From a legal perspective, I think I'm not an expert on this topic, I must confess. I think the European Court of Justice basically has, its territorial jurisdiction is linked to the European Union as such. However, if you might be a creative lawyer, you might say that if, of course, you would cut down forest in Latin America, that has also an impact on climate change and might indirectly put in jeopardy the effectiveness of Europe's climate pledges. I mean, climate is interconnected, so, and its causation at that point of you would have to argue a flexible interpretation of the causational link. I think it's possible if you take into account climate change, but it's uncharted territory, I think, unless my colleagues correct me.
No, just to say that I agree, and to add that there are some campaigns from NGOs in Europe acting against banks, which give the money to companies to extract in the south. So.
Thank you. Sorry.
No, it's okay.
Final question.
No? Yeah. So, well, it's more a comment than, well, maybe it's a question, I don't know. My question regards to the idea of nature rights as a cultural inclusion in the constitutions, in regards to what extent those constitutions wanted to change society with recognizing those rights, or the role of the law changing society. So when you say that it didn't work, it's because the law was not able to change society, and it's at the end the system stays the same as it is, because society doesn't matter. The people is not really worried about the environment or the nature. So to what extent all this idea of creating rights to nature is to change the mind of people, or to giving rights properly to nature?
Good question.
Yes, that's very interesting. I think it's, of course, it's also, and it has also been instrumentalized politically in those countries, because it was a way to resist to the Occidental model of the rule of law, neoliberalism, etc., etc. So it's hard to make it clear, but what I can say on an academic point of view is it's just that this relation between law and society took me 6 years of my life doing my PhD, because I studied the effectiveness of environmental law. And the conclusion, so my topic was to identify the legal conditions of the effectiveness. So what are the elements in the legal system that will have an influence? So that's why I was speaking about secondary norms instead of primary norms. But what are those conditions? And my ultimate conclusion was that, okay, we can identify legal conditions, but there's also extra legal conditions, and there's a lot of it. And I'm not a sociologist, I'm not an anthropologist, and I'm not qualified to identify those other conditions. But now I'm trying to work with other scientists to try to understand the whole picture.
Thank you very much. I suspect you will agree with me that it was an incredibly interesting and lively debate, and I suspect also we will resolve some of the issues tonight over copious amounts of alcohol, which is probably what we'll need after such a very interesting debate. So please join me in thanking our speakers for their time and effort. Thank you.
Thank you.